5 seconds to go. Start. The instant appeal is directed against the order passed by the High Court of Guwahati dated 3rd December, 2021, declining to interfere with the order passed by the Additional Sessions Judge, Fast Track Court in Sessions Case number 57 of 2012, rejecting the discharge application filed by the appellant under Section 227 CRPC. Stop. Para. The seminal facts relevant for the purpose are that on 28th April, 2009, an FIR was lodged by one Shrimati Razia Islam, mother of the deceased, at police station stating, inter alia, that her son was burnt to death under suspicious circumstances inside his rented house at Sivas Nagar by his wife and the present appellant. Stop. Her son succumbed to the injuries sustained by him while on the way to hospital. Stop. On receipt of the complaint, an FIR was registered at Siva Sagar PS case number 198 of 2009, under section 302 IPC. Stop. The police filed charge sheet under sections 302 oblique 120B oblique 201 oblique 118 IPC against 3 persons, wife of the deceased, and the present appellant, along with a list of 13 witnesses. Stop. The only allegation levelled against the present appellant was that he had, in conspiracy with other accused persons, removed the evidence of offence from the place where the alleged crime had been committed. Stop. Para. The learned trial judge, initially by order dated 21st June, 2012, after hearing learned counsel for the appellant, came to the conclusion that there is prima facie case against him and others, and fixed 17th July, 2012 as the next date of hearing for framing of charge, and thereafter, charges were framed against accused and the appellant under sections 302 oblique 120B IPC and under section 201 IPC against the appellant by the order dated 17th July, 2012. Stop. Para. The revision preferred by the appellant against framing of charge came to be dismissed by the High Court under the order impugned dated 3rd December, 2021, which is the subject matter of challenge in the present appeal. Stop. Para. The main thrust of the contention of the counsel for the appellant is that the appellant has no nexus with the commission of crime. Stop. He was a friend of the deceased working in the same office. Stop. At the time of the incident, the appellant was working for the Indian Oil Tanking, a joint venture of Indian Oil Corporation and Oil Tanking of Germany, as project engineer, Siva Sagar. Stop. On the fateful morning, the appellant received a telephonic message from the wife of the deceased that her husband had sustained burn injuries and requested him to come to their house, and after receipt of the information, he, along with other colleague, came to the house of the deceased by his car. Stop. Seeing burn injuries on the body of the deceased, he along with Rafiq took him to the nearby nursing home at Siva Sagar, and after preliminary treatment, he was taken to Dibrugarh Medical College, where he succumbed to the injuries. Stop. So far as the present appellant is concerned, his intention was only to help out the deceased in getting proper and immediate medical treatment. Stop. Except this, there is no nexus of the appellant in the commission of alleged murder of the deceased, and there is no material against him, and no witness has deposed against the appellant. Stop.